I'm Taylor Holland. I'm a senior associate in the Edmonton office. My practice focuses on all aspects of labor and employment law. I'm also a member of Dentons Canada's Workplace Investigations Group, and I assist with workplace investigations conducted by the Edmonton office. I'll be your moderator for this session, and today I'm joined by three panelists, all with diverse workplace investigation experience. All three panelists act as independent workplace investigators. They also each provide advice to employers navigating their own internal investigations. The first panelist is Alison Walsh. She is a partner out of the Edmonton office. Alison has extensive experience in all aspects of labor and employment law. She is the co-chair of Dentons Canada's Workplace Investigations Group. She is a trained workplace investigator with experience conducting workplace investigations related to allegations of bullying, harassment, sexual harassment, violence, and ethical violations. Our second panelist is Cristina Wendel. She is a partner of the Edmonton office. Cristina has extensive experience in all aspects of labor and employment law. Cristina is the leader of the Alberta Occupational Health and Safety practice. She is also a member of the Dentons Workplace Investigations Group. Cristina is a trained workplace investigator who has experience conducting investigations related to allegations of bullying, harassment, sexual harassment, violence, ethical violations, and conflicts of interest. The third panelist is Victoria Merritt. She is an associate in the Vancouver office. Victoria has broad experience in all aspects of labor and employment law. She is a member of Dentons Workplace Investigations Group with experience conducting workplace investigations related to allegations of bullying, harassment, sexual harassment, and discrimination. Victoria is also primarily interested in trauma-informed approaches to investigations, and this has been a focus of her professional development. And that takes us to the beginning of our discussion today. So the first thing we're going to go through is just some preliminary considerations as to why you should investigate and when you should investigate. So firstly, when is an employer obligated to conduct an investigation? There are many reasons that an investigation may be triggered. They can relate to allegations that come from an employee, a customer, a contractor, or a third party. Typical allegations that trigger investigation obligations include incidents of discrimination and harassment, allegations of abuse and violence, incidents of theft or fraud, allegations of conflicts of interest, allegations of breaches of workplace policies, and other dishonesty that may be alleged through complaints. This brings us to why employers should conduct an investigation. There are legal obligations placed on employers to conduct investigations. These include obligations through occupational health and safety legislation that primarily relate to allegations of harassment, discrimination, and violence. Similarly, there may be legal obligations under human rights legislation to conduct these investigations, and also as a protective measure for allegations of constructive dismissal to show that the employer has taken steps to address these various allegations. We have also seen courts, arbitrators, and tribunals recognize that allegations of serious misconduct may have a significant impact on an employee and must be properly investigated before the employer can act on any such allegations. Adjudicators have actually imposed an obligation on employers to conduct a fair and effective workplace allegation. This is in the interest of both fairness to the complainant and the respondent in dealing with these serious allegations. There is also potential liability if an employer fails to conduct a workplace investigation, fails to conduct the workplace investigation properly, or fails to discharge its statutory obligations to investigate if they're applicable. Finally, many of these serious allegations can involve reputational impacts on employers. That is best to conduct a fair and effective investigation in order to protect reputational considerations. And now this brings us to our panel discussion. Again, if you have questions, please place them in the Q&A. I see that some are already coming in, and we will do the best to address them as we go. But the first question that we want to ask is, when does a complaint need to be investigated, and who should conduct the investigation? And I will ask Alison to speak on this matter.
So not every incident obviously is going to trigger a requirement to conduct an investigation. And so Taylor's already gone through kind of some of the key points of when to investigate, but a helpful question to ask yourself when assessing, do I need to investigate, is consider if this matter complained about is true, does it breach our workplace policies and therefore trigger a requirement to investigate? Again, you want to consider, does the complaint create a legal obligation to investigate? And then alternatively, does not investigating create liability for the employer? So for example, occupational health and safety legislation creates a legal obligation on the employer to conduct workplace investigations with respect to workplace violence and workplace harassment. Similarly, human rights tribunals expect employers to conduct investigations with respect to allegations of harassment, and failure to do so may result in actually increasing the damage exposure for employer, while alternatively, if you conduct an investigation, that actually can help mitigate your damages. And then in addition, judges and other adjudicators expect employers to conduct investigations or where there's a situation to give the other side an opportunity to respond. So in particular, they're concerned about giving employees an opportunity to respond to any serious allegations against them before decisions with respect to discipline or termination are made. And so the investigation will not only allow you to gather facts to help you make a better decision in terms of what next steps should you make, but in that process, you also then are giving the respondent an opportunity to respond, and you're meeting that duty of fairness obligation that the courts are placing on employers. Once you determine that an investigation should occur, so the next question is, well, who should conduct that investigation? Investigators can be either internal, so normally this would be a human resources personnel, but they also can be external, which often are either external legal counsel or even human resources firms. When choosing internally who should conduct an investigation, there's a number of factors you want to consider. So the first is you always want to make sure the person conducting that investigation is neutral and unbiased. And so this means the investigator should not be directly reporting to either the complainant or the respondent, and the investigator should really not have any involvement in the matters that are being investigated. It also is important, if possible, to try to get someone who's kind of is removed from the situation, not only the specific facts, but even the individuals being investigated. So you want to avoid someone who closely works with any of the parties being investigated. It's important that that investigator has the proper training and expertise about how to investigate this type of complaint. And they also need to be available to investigate it promptly, because you do have a duty to conduct your investigation in a timely fashion. Alternatively, if you're weighing whether, should it be an internal investigator or should be an external investigator, there's some other factors in that situation you want to consider. So, first look at the nature and the severity of the allegations. External counsel or an external investigator is going to be potentially more appropriate if what's being complained about involves a high-risk situation that may ultimately lead to some legal liability and legal exposure to the employer. Similarly, if the employer wants to maintain privilege over the investigation, in that case, an external legal counsel may be appropriate to try to maintain that privilege. Another factor to consider is the identity of the person who the allegations are made against. An external investigator may be more appropriate where it's a senior person in the organization, where an internal investigator may have difficulties, showing neutrality or being unbiased if it's someone that they normally report to. You may need to go outside your organization if the complaint requires special expertise. So this could either be legal expertise, or the nature of the complaint may require that you need to get someone who has financial auditing experience or, IT technical experience or so forth. And then again, it's always important that your investigation is neutral and unbiased, and also is viewed from the outside as being neutral and unbiased. And so there may be dynamics that make it important to bring in someone external from your organization so you can clearly demonstrate that neutrality. And this is normally, again, it's kind of, we see this situation or this requirement where it's a senior person within your organization. And in order to show that that investigation is completely neutral, you may need to bring in someone external. And then lastly, again, consider availability. So do you internally have the ability or the capability to conduct this investigation in a timely fashion? If you don't, and if an internal investigator is not available, in those circumstances, you may need to hire someone externally so you can make sure the investigation is moving forward promptly.
Thank you, Alison. The next question that we have is, what are some best practices to ensure you are engaging an effective investigator? And I'll turn this to Victoria to provide the answer.
So this is going to build a little bit off of what Alison was already talking about, but there's now quite a few options when you're looking at retaining an external investigator. And it's important to make sure you are retaining someone who's going to do all of the things and achieve all of the objectives that Alison was just talking about when you are looking externally. As with engaging any other professional, a great place to start is referrals. So asking your colleagues, who have you retained? What was your experience like with them? Asking your lawyers or people in-house for recommendations, always a great place to start. You then, of course, want to review their qualifications. As Alison already referenced, do they have the specific training that you're going to need for this type of investigation? What's their experience? When you meet with an investigator, you're going to want to actually take that opportunity to basically interview them and find out if they're going to do what you need them to do. So you can ask questions, for example, what's your process for conducting an investigation? They say, oh, I don't have one, or I wing it, there's a red flag for you. Hopefully they're going to walk you through what you're going to, again, be expecting them to do in an investigation. How do you resolve conflicts in evidence? That's very important. If they say they don't, that's again a problem. Ideally, they're going to understand the credibility analysis that goes into that. Kind of a similar question would be, have you ever been unable to make a determination at the end of your investigation? There might be some circumstances where that's perfectly understandable, but if that's that happens often, again, that's maybe a bit of a red flag. And of course, as you're asking them to kind of review with you what their normal steps are, you're going to be assessing their demeanor, their confidence, their knowledge, how they interact with you. And that should help give you a sense of whether they're somebody you want to retain. You'll also want to ask them to give you a quote in terms of costs. I'm sure we all know retaining external investigators can be costly. So you want to know what their estimate is. You also want to confirm their timeline and availability, similar to when you're looking internally. Are they actually going to be able to get this done in the time that you need? If they're a really well-respected sought-after investigator, they might have a really big file load at the time and might actually not be able to get to it. And again, then maybe you're asking that person for a referral. And finally, you sort of want to look at the fit and the optics. And again, this really goes back to some of Alison's points about, is this something where you need somebody who's going to be a little bit more sensitive in their approach? Do they need to have specific qualifications or expertise? And are there any optics to consider? So again, you don't want to retain an external investigator who doesn't actually appear to be biased. So they're the granddaughter of the CEO or something like that, or related to the person being investigated. Obviously, any optics like that, you just, again, need to be cognizant of in the same way you would when you're looking internally. So just a few tips, and I'll turn it back to Taylor.
Thank you very much, Victoria. Now we'll turn to the next question, which is, if the external investigator is not a lawyer, but a trained workplace investigator, how does this impact privilege? We also have a question from the audience and what exactly maintaining privilege means. So Cristina, I'll maybe let you speak to this question and also address the audience question of what does it exactly mean to maintain privilege.
Sure, thanks, Taylor. So if you're not using a lawyer as your investigator, it's going to make it more difficult to establish privilege. But even when you are using counsel, it's often just not possible to successfully establish privilege over an investigation, particularly over the investigation report. Maybe to back up, there's really two types of privilege that would attach to an investigation and to the investigation report. The first is solicitor-client privilege. That will only attach if you have counsel or a lawyer as your investigator. And that applies to communications that are between a client and the lawyer that are made during the course of seeking or giving of legal advice. So that legal advice is an important component of it. And those communications are meant to be confidential by both the client and the lawyer. And as I noted, it's really that element of advice which makes it difficult in many instances for this privilege to actually truly attach to an investigation. Typically, the investigator is making findings of fact and often is not actually providing advice to the client as the investigation goes on. So that's the one main kind of privilege, but you can also have what's called litigation privilege, and that applies to communications or records that are created for the dominant purpose of litigation. So it's called the dominant purpose test. And that litigation doesn't have to be an action that's already been commenced. It can be anticipated. So if there's a party that's concerned that they're going to be sued or they're going to be charged with a regulatory offense, for instance, then that can fit within the litigation privilege test. And that will arise even in the absence of a solicitor-client relationship. So it applies to all litigants, whether or not they're represented. And you often see that attach in lawsuits where someone's retained an expert report, for instance. The expert is often an expert in their field, an engineer or a physician, and not a lawyer per se, but the privilege attaches because the dominant purpose of retaining them and getting them to provide that investigation or that expert report was for litigation. Now, when we're talking about a workplace investigation report, the dominant purpose test often is not going to be met. And again, it's the dominant purpose. So when challenged, so say you have an investigation report, you claim privilege over it, the matter ends up into litigation somehow, and there's a challenge as to whether or not that privilege claim is legitimate or is going to be accepted by the adjudicator. The question is whether that dominant purpose test has been met. And when you're asking, well, what was the dominant purpose for that investigation report? In many instances, it's not going to be for litigation. Why do you have an investigator retained? Why are you preparing an investigation report? Well, typically it's to comply with your legal requirements, whether it's OHS or common law or policy, and not for litigation truly. I'd say you don't often, in these instances with a workplace complaint, retain an investigator for the dominant purpose of making sure you're covered in litigation. So in terms of maintaining privilege, let's say this is something that you want to have privilege over, then you would want to be able to attach both kinds of privilege, so the solicitor-client and the litigation privilege, and then have that addressed with the investigator at the outset. So when they're retained, when they're engaged, include that in the terms of engagement, that they are also being retained to provide advice about how to manage the complaint and how to manage the outcome of the litigation. Then that will put you in a better position to be able to attach that solicitor-client privilege. In terms of maintaining privilege, it's just a matter of being consistent in terms of keeping it very confidential, not disclosing it to third parties, because then you can run the risk of ruining the privilege if, of course, it attaches in the first place. One of the things that we'll often recommend, particularly in occupational health and safety incidents, is to have basically parallel investigations. So you have one investigation that the dominant purpose would be to comply with your statutory obligations. But then you also have a parallel investigation, which we sometimes call the warts and all investigation, which is really a deeper dive, and it delves further into the root causes and the bigger issues at play. And that is one way that you can try to maintain privilege over it. So you have one report that really satisfies your statutory or policy obligations, but then you have a secondary report, that deeper dive report, that you can hopefully have a better chance of actually legitimately claiming privilege over, because the dominant purpose of that investigation and that report was to provide advice and to assist you when or if the employer is charged or is brought into a lawsuit. So those are some of the considerations to keep in mind in terms of privilege. Privilege is a whole another topic, but hopefully that answers those two questions.
Thank you, Cristina. The next question that we want to address is, can the complainant or the respondent bring a support person to the investigation interview, for example, a friend, coworker, or lawyer? We also had an audience question that involved what obligations come when there is a union involved in the matter. So Alison, if you can maybe address those two questions.
Thanks, Taylor. So there's basically three kind of categories of support persons that may want to be participating in the investigation. The first would be a lawyer. And normally an employee does not have a right to have counsel present during an interview. However, as a practice, I would generally allow counsel to be present. And that is because the main purpose of the interview is to try and get the best evidence. And so if the party is only willing to be interviewed with their counsel present, it's better to go forward with the interview with counsel. And you also don't want to, at the offset, create kind of tension if you're saying, no, you can't have counsel present, and you're insistent on it. And now the individual you're interviewing is kind of antagonistic to you, and so they're adverse to you because you've already had this conflict. So ideally, it's better, in my experience, to allow the counsel to be present. There's also situations where the allegations, particularly against the respondent, may have further legal consequences. So, for example, if there's allegations of sexual harassment that could lead to criminal charges, in that case, I would make sure that the respondent is advised that he has an opportunity to seek legal advice. And if in that situation, if they wanted their counsel present, I would allow, counsel to attend. That being said, if you do allow counsel to attend, you do want to make sure that you set up some ground rules for the lawyer's participation. So first, you want to make it clear that the counsel is there to support the individual. And so they need to allow their client to speak and tell their own version of events. They shouldn't be interrupting their client or interrupting the investigator during the interview process. And they shouldn't be making any submissions or otherwise advocating for their client during the interview process. So that's not the purpose of the investigation. That is not the purpose of the interview. And so you want to lay those ground rules out at the onset, so everyone knows going in, how to conduct, how this investigation or how this interview is going to go out. In terms of union representation, so tying back to the question that Taylor just posed. So unlike legal counsel, unionized parties may have a right to have a union rep present during the investigation process. This is determined by the collective agreement, and generally it comes from provisions in the collective agreement that allow parties to have union representation for any kind of potential disciplinary meetings. So really, unions tend to take a position that if an investigation could result in the discipline of the individual being interviewed, then the union has a right or the unionized party has a right to have a union representation in that interview meeting. Normally, I would allow a union rep to be present, and I usually inform the the individual being interviewed at the offset, if they are unionized, that, they should contact their union rep in order to get advice. In terms of the process of the interview, you want to lay out the same ground rules that you did for counsel being present, but there's also some additional considerations you have to be aware of. So unlike a lawyer, a union rep does not have a duty to maintain solicitor-client confidentiality. So you want to make sure that it's very clear to the union rep that there's an expectation that they're going to maintain the confidentiality of the interview. If there is more than one party entitled to union representation, in order to maintain confidentiality, I would recommend that the parties have different union reps, if possible, attending the interviews. Also, if the union rep is a witness in the investigation, they should not be representing any of the parties. And depending on that situation and how big the union is, in that case, you may need to look to getting a union rep either from a regional offices or national office to act as the representation for the unionized parties in the interview. So beyond just being present for interviews and acting as a union rep in the investigation process, the other roles that the union may have that can be helpful in terms of in like making sure the investigation process goes smoothly. They might be there in order to provide support for the complainant. They can be helpful, maybe potentially in a situation where you have a complainant who is uncomfortable with the interview, or maybe they're looking to try to back out of participating. And then in that situation, you might want to involve the union to help you and assist in kind of understanding why their member doesn't want to participate, and perhaps they can provide that support to get that individual comfortable so they are participating in the investigation. The union can also be helpful if there's multi-party investigations. So I think the prime example would be like in a construction site where maybe you have multiple unionized parties, and then involving the union there might be helpful in terms of organizing the investigation process. In terms of the last category of support person, that would be your family member or your friend who that the interviewee wants to bring to provide them with support. And again, I generally don't have any objection to a family member or a friend coming as a support person, but again, like the same ground rules for lawyers and unions have to be set out. And in particular, you want to make sure that that support person understands that they're there to provide support, but they have to allow the party to tell their own version of events. And it's also very important that they understand that they need to maintain the confidentiality of the interview process. If a support person is a coworker, you want to make sure that they are not a witness. If they are a witness, they shouldn't be attending any interviews as a support person. You also want to make sure that any non-coworker support person is not a potential witness, and this includes that they're not a confidant witness. So this would be someone who doesn't actually have firsthand evidence of witnessing the events, but there's someone that the complainant spoke to at the time of or closely after the events, which may provide a corroborating evidence later on in your investigation. So those are the kind of three support people that you generally see in an investigation process.
Thank you, Alison. We had a couple follow-up questions from the audience on this topic. And one of the questions was, what should these third-party people be signing a confidentiality agreement? And also, if there is a confidentiality agreement, how does it impact a person seeking advice from a lawyer?
So in terms of a support person from a confidentiality agreement, so that is one option. Like it depends on the investigator. I don't always see a confidentiality agreement. Often what is common is that at the beginning of a investigation, you kind of go through some recitals in terms of, laying out the process, reminding the individuals of their, confidentiality obligations. You also want to make sure that you're reminding them of those obligations at the offset. So when, they're first contacted to advise that there is going to be an investigation, part of that is also reminding them of their confidentiality obligations. One way, if there's a concern that there may be a breach in confidentiality, You can consider having like a very, pretty straightforward confidentiality agreement to get for like a support person to sign if you are concerned about, breach of confidentiality. The benefit of that is, the fact that someone is signing something, it may hone to them the importance of these obligations. In terms of signing a confidentiality agreement and getting legal advice. So I think you always should allow a person to get legal advice. You would never want to term in the confidentiality agreement that limited their ability to get legal advice. And there isn't really a concern on a confidentiality front with a party speaking to a lawyer, because there is that solicitor-client confidentiality, and there's that obligation on a lawyer to maintain confidentiality. And so I think the individual should still have, if they sign a confidentiality agreement, I would create an exception to say, like, you can still go and get legal advice, and make sure that's clear to the individual and that they aren't having a kind of misunderstanding that they think this limits their ability to get legal advice. You don't ever want a situation where the person subsequently says, well, I signed this and I didn't get legal advice, and I would have proceeded differently if I could.
Thank you, Alison. The next question is, how do you navigate a complaint where the complainant declines to participate? And I'll turn this to Victoria to answer this question.
So this question, I think, would also include situations where a complainant maybe is unable to participate for an extended period of time. For example, they have medical issues or they've left. So it's important to note at the outset that in some cases, you're still going to have that obligation to investigate, regardless of whether the complainant wants to participate or is able to participate. And even if you're not obligated, you might still want to investigate. So this is kind of the warts and all Cristina was talking about. Maybe there's a reason you want to be looking into the complaint on top of any legal obligations. For example, there's really high turnover in a particular group and you've received a bullying complaint from someone about someone in that group. So one of the first steps for a complainant doesn't want to participate and is there is to find out why. So what's the barrier for them in actually participating in the process? And then if you're able to determine that, work with them to hopefully address it. So for example, if they're worried about retaliation, they're scared what's going to happen to me if I participate, providing them with the assurances that retaliation is prohibited, the protections in place for that. You might offer them a support person, let them know that that is available for them if they find it difficult to talk about, and that's the reason. And sometimes just providing more information about the investigative process to them can help kind of alleviate any concerns that they have about participating in the process with you. So ideally, you're able to kind of work through it with them and have them agree to participate. If they remain unwilling to participate, you're going to want to make sure that you've kind of documented your attempts to engage them in the process for the investigative record. You're also going to want to ensure that they understand, I don't want to say the consequences in a punitive way, but that they understand that even if they're not participating, the investigation is going to continue on without them. And, explaining to them a little bit about how their refusal to participate might impact your ability to investigate the complaint. And then again, sometimes that will encourage participation. Alison flagged that you can also potentially utilize the union to help you, again, with explaining the process, what their role is, the benefits of participating in the complaint. Ultimately, you might have a situation where you have to investigate and you aren't able to interview the complainant. That's not the end of the world. You're going to rely on the best evidence you can. Hopefully, it's a situation where they submitted a written complaint, because in some way the complaint came into you. So whatever that initial information is something that you're going to be able to rely on. And then finally, we'd also recommend that before you wrap up the investigation, you give them a final opportunity to participate. And I think that's especially important if it's an investigation where it's looking like the complaint's not going to be substantiated, giving them that final opportunity to participate. And again, going through everything and ensuring it's documented that they had every chance, just to ensure that it's very clear it was a fair process and they chose not to engage even though they were given multiple opportunities.
Thank you, Victoria. The next question is, how do you navigate a complaint where the complainant wishes to remain anonymous? And how do you address maintaining confidentiality during that investigation process? And I'll turn this to Cristina for her comments.
Thanks. So to start with the first question there, navigating a complaint where the complainant wants to remain anonymous. How you can proceed with that will really depend on the nature of the complaint and whether it is something that can be investigated properly and fairly without knowing or disclosing the complainant's name. So for instance, if you have like a whistleblower type complaint alleging, for instance, financial improprieties, you may be able to proceed with an investigation of the complaint by looking at the books and records, things like that. And in some instances, the identity of the complainant may not be particularly relevant or critical to the investigation. They've given you enough information to let you know where you need to go and what sources of records you need to go to proceed with the investigation. But if what you're faced with is a complaint, let's say for instance, a harassment complaint against a specific individual, alleging specific harassment, an incident, on a certain date and time, it's going to be virtually impossible to properly, fully, and fairly continue with that investigation without disclosing the complainant's identity to the respondent. And in those cases, I mean, that disclosure is important for the fair process. So fair process requires that there is that disclosure to the respondent. They need to know what the complaint is that's being made against them and the specific allegations so that they have the opportunity to properly respond. Now, in some instances, maybe the anonymous complainant has given you enough information so that you can still proceed. So you really do have to look at what you have and analyze that to determine, well, okay, how can I proceed with that? Now, if you feel as the investigator that you need more information and you really can't move forward very well with the limited information, then this will kind of raise a lot of the same points that Victoria mentioned in the previous question, where the complainant does not want to participate. So talk to the complainant, find out what the issue is, offer them support, offer them more of an explanation. If there's a union involved, you can involve the union as well if they're aware of this. So see if they can provide some assistance and some encouragement to encourage the complainant to come forward, knowing the consequences that you won't be able to do a proper investigation without that. Now, in terms of the second question about addressing maintaining confidentiality, now, if the complainant does agree to disclose their name, this is where that really becomes important because you need to ensure that the complainant knows what that means. And sometimes when you hear okay, well, the investigation is going to be confidential. Sometimes I think complainants think that means more than it really does. It doesn't mean complete confidentiality. You can't guarantee complete confidentiality. There has to be disclosure as part of the investigation process, for instance, to the respondent. The respondent, as I said, needs to know what the allegations are against them so that they have the fair opportunity to respond. So you can't promise complete confidentiality, but what you can say is that it's disclosed on a very limited basis for the purposes of the investigation, on a need-to-know basis only. You should, though, check the policy, any sort of legal obligations that trigger disclosure. So I have seen, for instance, some employer policies that require that the investigation report be disclosed to the complainant, to the respondent, to the union. So you need to know going into it what those disclosure obligations are going to be so that you know that you're informing the complainant properly. So another thing we often see in some of the policies is a requirement to provide a written statement, and then the policy actually provides that the written statement is sent to the respondent, or there's statements that are going to be exchanged between them. So in that instance, again, you need to make sure that the complainant is aware that they're providing this written statement, and this is what's going to be done with the witness statement so that they're not caught off guard by that. Thanks.
Thank you, Cristina. We had some interest from the audience in what does an employer do in a situation where a witness wants to remain anonymous?
And that might be easier to manage. Again, it'll depend on who the witness is and how are they involved in this. And with witnesses, typically you want to disclose as little as possible to them, right? You only need to give them the information that they need to answer the question. So you're not faced with the same issues necessarily as the complainant. But if the witness has a significant amount of information, kind of almost to the point of new allegations against the respondent, then that's going to put you in a very similar situation where you do need to be able to provide disclosure. So it really depends on who that witness is and how they fit into the investigation. But in many instances, I'll say in a lot of the investigation reports I do, I'm not identifying who the witnesses are. Certainly the respondent, the complainant, the parties often do not know who you've spoken to. From often employees will speak amongst themselves no matter how much you tell them to keep things confidential. So there's some knowledge that can trickle out that way. But in terms of the investigator, I mean, I'm not going to go to the respondent and say, this individual said that you did this, or that they witnessed this, or that the complainant reported to them on this date, unless it is something that's critical for the respondent to have the opportunity to respond. So with the witness, it is often possible for them to remain anonymous.
Thank you, Cristina. The next question, and we had a lot of interest on this topic from the audience. How do you conclude an investigation where the parties have conflicting stories and there are no other witnesses? For example, a he said, she said situation. And I'll turn this one to Alison for comment.
So this is obviously probably the most difficult situation for an investigator in order to coming to a final conclusion. But at the end of the day, it's important to note that even if you have a situation where there is no other witnesses and it's just two conflicting stories, your obligation as an investigator and your role does require you ultimately to reach a conclusion. And that conclusion is, based on a balance of probabilities. So how do you get there? And so there's a number of things to consider. So first, consider, is there any other corroborating evidence? So you might not have witnesses, but maybe there's documentary evidence that you can look at and you can review. So text messages, emails, is there video cameras? Is there building entry records? Is there, computer records that you can review in order to corroborate the parties' stories? You might also want to consider the evidence of a confidant witness. So again, this is someone that the complainant spoke to about the events. And so the best type of confidant witness is if the confidant spoke to the complainant close to the time of events or shortly after. A confidant witness isn't always going to be useful, but if it is someone that they spoke to close to events, that would be, potentially a helpful witness or evidence to consider. While corroboration is helpful, it's not necessary in order to make findings of fact. And if you think about it, there's types of behaviors that tend to only happen when no one else is around. So, the obvious example would be sexual harassment. I apologize. The obvious example would be sexual harassment. And so if you decline to investigate in those situations because there's no witnesses, you'd never have finding of facts on that type of allegation. So obviously you still have to be able to come to a conclusion. And so this requires you to basically conduct a credibility assessment. So you're going to have to assess both the honesty and the reliability of the witness. And so there's a number of questions that you can ask yourself to help you make that credibility assessment. So for example, consider, or ask yourself, how would you assess that individual's powers of observation? How would you assess their judgment and their memory? Do they have an ability to clearly describe what they saw and heard? It's also important to remember that an honest witness might not always be a reliable witness. So you can have a situation where someone is telling a story that they believe to be true, but because of other reasons, their evidence might not be reliable, and it could be memory or other influences that's affecting that. Another thing you can consider, or you should pay attention to, is how are the parties answering the questions that you pose to them? Sometimes you'll get an interviewee who doesn't want to answer your question directly, or you ask them a question and they try to ask you a question back instead of answering, or maybe they'll try to pivot to another topic for conversation. So these are all, potential indications that maybe they're trying to avoid answering your questions, or maybe they're avoid on answering honestly, and so it can raise issues about their credibility. Also, just take a step back and look at the information that you've been provided and ask yourself, does this make sense? Like, does the evidence fit with what a reasonable person would expect to happen in the circumstances? Consider how the evidence is being given in terms of, is the person being interviewed, are they balanced in terms of their evidence? And so one way to assess this is the individual that you're interviewing willing or capable of admitting to shortcomings? Are they capable of admitting to evidence that's potentially adverse to them, which may suggest that they're, being more honest in their evidence? Consider whether the individual is consistent in terms of their evidence. So if they've been asked a question more than once, do they give the same answer each time? You can also consider body language and demeanor. So this would be like averting gaze and raised voices, but I would really caution against putting a lot of weight, if any, on body language, because it really isn't a reliable tool. And that is because many of the behaviors that are exhibited when someone are nervous or stressed may be the same behaviors that you're attributing to being someone dishonest. So someone may be shifting or averting gaze because they're nervous because they're being interviewed, and it doesn't necessarily mean they're being dishonest. So I would caution of putting much weight on that type of observations. And then the other thing to consider, is the individual giving you firsthand evidence, or are they giving you hearsay evidence? So finding of facts generally shouldn't be made on hearsay or gossip. So firsthand evidence would be the evidence that someone is sharing based on their personal experience. So an example would be if I said, I saw Taylor yell at Cristina. That would be personal, which she would never do, by the way, which would be kind of personal evidence. But then hearsay evidence would be at least once removed. So if I said, Victoria told me that she saw Taylor yell at Cristina, well, then that would be hearsay evidence, and it's less reliable because you're not getting the evidence firsthand. But again, like I said, at the end of the day, even though it is more difficult when you're dealing with these he said, she said situations, and it's, and you're relying on really a credibility assessment, you still, as an investigator, have an obligation to make a decision one way or the other. And it's also important to remember that the standard that you're applying is a balance of probabilities. So you just have to, reach that standard. And so, if it's 50% plus one in one way or the other, that's the balance of probabilities that you use, or the standard that you use to come to your final conclusion.
Thank you, Alison. The next question is, how do you manage investigations on multi-employer sites? And I'll turn this to Victoria for her comments.
Yeah, so this one, again, this is if you're in a multiple employer site, you're not going to be off the hook in terms of doing investigations. Just a bit can get a bit more complicated, although not necessarily, as we'll talk about. So one of the first things to do is going to be to review the applicable occupational health and safety legislation. And so, as we know, bullying, harassment, violence, they're all considered workplace hazards. So there's a number of legislated obligations around investigating those, which we kind of touched on at the outset. And then those obligations are going to continue to exist on the multiple employer site, which is addressed in health and safety legislation in each jurisdiction. So you're going to want to start by confirming who you are under that legislative scheme. So for example, if you're the prime contractor, you're going to have certain obligations in addition to those you typically would, including potentially coordinating other employers to action an investigation and making sure things aren't falling through the cracks on the work site. As an employer, you're going to have all your usual obligations. And you might have some reporting obligations, or coordinating obligations or obligations to participate in other people's investigations. And you might have obligations under multiple roles simultaneously, so as prime contractor and as employer. Aside from health and safety legislation, though, you'll also want to review your contracts to confirm if there's any disclosure or reporting obligations in the context of an investigation or a complaint. So what do you have to report and to whom, and by when, are all questions you want to answer, and ideally know, and then comply with that as you're required to under the contractual arrangements that are in place between different parties. And in terms of the investigation itself, this goes back to where I said sometimes it's not more complicated, and that would be, it depends who's involved. So if the complainant, the respondent, and the witnesses are all your own employees, other than those potential reporting obligations we just talked about, that's going to be your fairly straightforward, normal investigation, right? You have access to all the parties and you're going to proceed with your investigation. Where it gets more complicated is when you have witnesses or the alleged bully or harasser is someone from another employer. And that's where it's important to be collaborating with other employers to ideally get access to those individuals to allow you to actually conduct a fulsome investigation. Again, I think Alison might have referenced this as well when she was talking about the role unions have. Often this is the type of worksite that is going to have unions. They might, again, be able to help in coordinating. And of course, the prime contractor might be able to help you in coordinating. Practically speaking, I think, all employers and the prime contractor and everyone on site has an interest in being fully compliant with health and safety obligations. So usually, there's a fair amount of willingness, I would say, to coordinate between employers and between the site parties. Of course, ultimately, other workers might not cooperate, or there might be practical challenges. This is where, the standard health and safety and common law would be reasonableness. So you've taken every step possible to get the best evidence you can and to conduct as thorough an investigation as possible in the circumstances. Your exact obligations are going to vary between provinces, as each legislation and regulatory body is going to be a little bit different. And of course, we can go back to the fact that there's lots of practical and business considerations as well in terms of the relationships on a multiple employer worksite. And this is a situation where, depending how complicated or how serious the complaint is, or if you're running into hurdles, it might actually be a good idea to get some legal advice in terms of handling these types of complaints.
Thank you, Victoria. The next question is, can you start an investigation if the respondent is on a leave of absence? There's also been a couple questions from the audience about whether a respondent's refusal to participate in the process can lead to discipline. So Cristina, if you could maybe comment on both those points, I'll turn it to you.
Thanks, Taylor. So in terms of a leave of absence, it really depends on what type of leave it is. But yes, you can and you should start the investigation even if the respondent is on a leave or is refusing to participate. And really, you need to get as far down the investigation process as possible. There's a lot that you can do throughout the investigation until you're at the point where you're speaking to the respondent. And so you may need to adjust your process so that you're not speaking to them as early in the process as you normally would. But if the respondent is unavailable and is going to be available, then you can kind of delay that or push that back and look at other things. You're going to want to talk to the complainant. You're going to want to interview the other witnesses, do the record review, policy review, all of that. Record gathering, information gathering is parts of the process that you can do without the respondent being available. Now, if the respondent's on leave, and once you've gotten to the point where you need to interview them, it really depends on what type of leave it is. So if it's a medical leave for stress, for instance, which is one that we do often see, then that's going to be different than if they're on leave because they have a broken leg, for instance. But I'd say anytime you have a respondent on a medical leave, you'll want to get clearance from their doctor before you speak to them. So you'll ask them, look, we've got this investigation. We want the opportunity to interview you. Can you ask your doctor if you're cleared to participate in this interview. And I mean, if it's something like a stress leave, you're probably less likely going to get that clearance. Whereas if they're home with a broken leg, broken arm, just recovering from surgery, you may be more likely to get that clearance. Now, if it's a parental or reservist leave, a different type of leave, you don't need that medical clearance, but you would ask the respondent if they're willing to participate even though they are on leave of absence. Now, if you can't get clearance or that agreement, then while not ideal, you may need to basically pause your investigation until you are in a position to speak to the respondent. I mean, if they're on a stress leave and their doctor has not cleared them, you certainly cannot force that issue. That's going to create some other difficulties and challenges for you as an employer. I know some of the concerns with delaying the investigation or delaying that interview is that, well, are you breaking up costs because the respondent's on leave? Just an important thing to remember that while you often put the respondent on an administrative leave pending the investigation, when they're on a leave of absence, that administrative leave should come to an end and they should transition to whatever type of leave it is, and whether there's some EI or some STD involved in that. The type of complaint is also going to impact how you proceed with this, but it's virtually all complaints are going to require you to speak to the respondent and give them the ability to respond to the complaint. Now, if the respondent is refusing to participate, typically you'll have obligations. They can be statutory obligations, but particularly in the policy should say, employees are required to participate in an investigation. So that is something that can result in discipline, but ultimately, like say, I had one where the respondent was a former employee. So as the investigator, we didn't really have that hammer to throw on them because they were no longer bound by the policy obligations to participate. And in those instances, you may need to just continue forward with the investigation and conclude your investigation without the respondent's evidence, right? Give them every opportunity to participate. Let them know that if they don't participate in an interview, you're going to conclude the investigation without their information. And then if they still refuse to participate, then you would just go ahead and make your decisions without them.
Thank you, Cristina. And we are kind of reaching the end of our time. I'll try and get through the next two questions that had a bunch of interest from the audience. As a reminder, this is being recorded. So if you do have other engagements, please feel free to attend to those, and you can look at the recording online. The next question that had interest from the audience was, if you find that a complaint was fabricated, how do you address this matter with the complainant?
So I can answer that. So you want to be very careful before you conclude that a complaint is fabricated or vexatious. It is possible that a complainant honestly believes that something happened, and just because you conclude that it didn't occur doesn't mean that the complaint is fabricated or the complaint is vexatious. So you want to make sure you actually have evidence of an actual improper motivation or like malice or before making a finding that the complaint is frivolous. If you do find that the complaint is frivolous, then you would deal with that individual and discipline them like you would for any other type of misconduct. And in this case in particular, I would make sure you refer to your policies, because generally your policies usually include statements that say making a frivolous or vexatious complaint may be subject to discipline. So if you do find that there's improper motivation in making that complaint and you have evidence of that, then you can go ahead and discipline the employee like you would in any other kind of misconduct situation.
Thank you, Alison. One question that had a lot of interest from the audience that I want to kind of forward to is, how do you address that a timeline for an investigation can be uncertain, particularly where a respondent is on a leave of absence pending the outcome of the investigation? And then the follow-up question from members of the audience was, is there a best practice in terms of a timeline for completing an investigation report?
Yeah, I mean, it's a good question. And unfortunately, there is no hard and fast rule for this. One of the first places to look is going to be your own policy. So one of the other questions I saw in the chat is if you have to have a policy on workplace investigations, depending on your province. Every province requires having or having a policy around bullying, harassment, and often workplace violence. And some of those do require having investigative procedures as well. And your policy might put a timeline in place that you should ideally comply with. Sometimes, frankly, that's impossible if you have a policy with, a 10-day time frame and it's a really complex investigation. I'd be curious if Cristina and Alison have a rule of thumb, but I think it's, again, a reasonableness standpoint. So it's going to depend very much on the nature of the complaint. And I think what's important, and I guess turning to this question, is making sure that you are proceeding diligently and your investigators proceeding diligently so there aren't unexplained delays. So there's reasons that investigations take time to do. With respect to this question, when you have a respondent who's away, and they're eager to get back to work and they're waiting to come back, presumably you've placed them on a paid administrative leave because there's a health and safety concern that needs to be addressed. You're going to want to be staying in regular contact with this individual and with all of the parties. And again, this is more broadly speaking, you'll want to ensure where it's appropriate that parties know the status of the investigation. Careful what you promise in terms of timelines, though. And again, this is where you might put a deadline on your investigator, but you don't necessarily want to communicate that deadline internally. You need to be realistic about what the time frame and be careful about what you're promising the parties, including the respondent. And in terms of, again, this person on leave, it'll be important to consider if there is a part of the if there's a time where it's appropriate to bring them back to the workplace, even if you don't have a full investigation report necessarily finalized. So that might be that, the results are kind of done, but you're waiting on the investigation report. Maybe with proper communication, you can actually bring them back to the workplace as long as there's measures in place as necessary. But in terms of the timeline, there is no hard and fast requirement absent your policy or something specific, depending on the complaint. It's a reasonableness standpoint. So being prompt, being communicative about the timelines, but also being realistic. And, in some cases, it does just take time to actually conduct the interviews, review the evidence and make findings.
If I could just add one point to that, the Canada Labour Code. So Alberta's statutory requirements don't delve into the details of what your investigation has to be, but the Canada Labour Code recently put in place some amendments. So they do have some very specific timelines on various stages of your workplace investigation. So if you're a federally regulated employer, you do have to be cognizant of those.
Thank you, Cristina. Those are also some very helpful comments. Thank you to all our speakers and attendees today. We hope you found this session valuable and informative. The presentation will be distributed with the relevant materials in our post-event email. We'd like to thank you again and have a great remainder of your week. We are cognizant of your time, and if we'll try our best to address the remaining questions that were put in the Q&A in the post-event email. Thank you, everyone, for your participation.